Tony, I have you here. I have you here on behalf of yourself, registered against the bill. Is that correct?
That's right.
Okay.
My name's Tony McDonald. I'm here on behalf of myself against the bill. I'm a practicing litigator in state and federal courts. A lot of what I've done with the TCPA is defending little guys. When a group of 20-year-old kids got sued for calling themselves young Republicans, I was able to tell those guys, hey, I can fight for you and defend you. And I was blown away when I saw this bill filed. I came out and said, this is the worst bill of the session. And why? Because it gives trial courts unilateral discretion, which is dangerous, and it allows the slap bullies to get their fees. And so if this were to pass as filed, it would absolutely destroy any ability of a lawyer like me or any citizen to rely on this act. So, I put that out there, and I said, this is the worst bill of the session, and Rep. DeAyala and I kind of snipped at each other, but then he said, hey, I'd like to talk to you. And so I'd like to say thank you to him for reaching out to me over the last couple days. I think he's headed in a much better direction with any substitute that he's going to work on. But as you explore that, I just want to emphasize kind of two principles. Number one, you absolutely have to keep the act reliable for Texans. People call me all the time afraid that they're going to get sued for participating. And I'm able to tell these people, hey, if you get sued for that, I'll have you back. Call me. I'll get you. And, if this act passed the way it was, and even with some of the proposed reforms, I worry that I can't do that. I can't tell people, yeah, you can speak. The second thing is you absolutely have to keep the courts of appeals in the driver's seat. Plaintiffs choose the venue. They choose where they sue. And, when they win in a venue where they sue, a lot of times they write the trial court order. And so, anything you do with this act, if you make changes, absolutely preserve the integrity of it, the reliability of it, and absolutely preserve, court of appeals control over these types of cases.
Okay. Tony, thanks. What do we do in my situation? Tony, I'm just going to direct this at you, but any of you can answer. What do we do? I'm going to bring up my personal situation, which you're well aware of.
Yeah, I'm very aware.
You and I've, it's been a while, but we've talked about it briefly.
An outrageous case, quite frankly.
So last session, was it last session? Yeah, last session I was served with a lawsuit regarding a tweet that I made, and I was sued by an individual in Parker County, and I hired great counsel and asserted my TCPA defenses and have won at every stage, have been awarded my attorney's fees at every stage, which now are totaling nearly $300,000 that I've had to pay. That that my insurance company is helping me with at the appeals court level, but I'm still wrapped up in that lawsuit over 2 years later, and I will never be able to recover my attorney's fees from the woman who sued me.
Yeah.
Ever. In fact, she has said that she's judgment proof, and yet I've had to spend now over $300,000 defending myself on that lawsuit.
Mm-hmm.
Is the TCPA working as intended?
I don't think it's strong enough. I think it could be stronger. Interesting. I've dealt with a case that's very similar, and I won't get into the personalities of it,
Sure.
right?
And I was very careful not to mention.
Yeah, but the idea of a third-party funder putting up a plaintiff to file a lawsuit on their behalf, I've got another case where that has happened, and it's got me looking into what.
But that's what happened in my case.
Yeah, so that's actually the common law doctrine of champerty, which if you were to bring back champerty, you'd have all of the third-party litigation funders down here lobbying against your bill, because that's a legitimate industry of third-party litigation funding. But it makes me question, should there be more ability to reach a little bit beyond just the parties in the case? If somebody's putting up the money on a vicious case, I really think that person ought to be liable. But again, I don't have a proposal or a solution for that.
And I'm not necessarily asking you for one, Tony. You're a smart lawyer, and I know we've sparred some over the years, but I do respect your opinion on this, and I know you've worked really hard to try to get this right. But I've now lived it, and I'm still living it, and I hear from litigants who the TCPA is not working as intended for them. I hear of judges whose courts are full of TCPA motions. I hear from major law firms, not Jackson Walker, but other similarly situated law firms, that literally have told their litigation departments, whether they're litigating family law, labor and employment law, whatever it might be, that in every case, whatever it might be, in every case, you have to consider asserting a TCPA cause of action or defense, because they're worried about being sued for malpractice if they don't. It's now become this instead of this shield, it's become this unwieldy sword that I don't believe that you guys with a straight face would be willing to admit it was ever intended to be. So I see when TCPA bills like this, and there were others, I filed one, Representative Meyer, others filed TCPA bills, and when we're maligned and attacked for reforming the TCPA, what I hear from y'all is that it's working as intended, don't touch it.
It is working as intended in a very important way, in that people believe that they can speak. They're not scared. And so it is working in that way. But I agree with you. I think it could be improved. I think there is an opportunity for us all to talk about ways to improve the fee recovery and that sort of thing. But one of the things Rep. DeAyala and I talked about, and I don't know if we totally agree, but I kind of said this rhetorically to him, is I don't think anybody in this, he said something about there's two sides. And I said, I don't really think there are two sides. Hopefully we're all on kind of one side, which is people who are slap victims ought to get their compensation. And if you file a frivolous motion, you ought to be, punished for that. And so I don't think there's really a lot of disagreement about that.
And again, this is not about my case, nor do I want it to be, but I'm
Sure.
living it, so I'm going to talk about it.
Yeah.
In that case, the plaintiff has really set forward a playbook. Go find, if you want to silence someone, a public official, let's say, if you want to silence them, go find a plaintiff who's judgment proof. Go find a plaintiff that has no assets, no money whatsoever, literally could never pay a dime of her own attorney's fees, much less yours, and go sue that public official into oblivion.
I think you need to start looking back at this is an ancient doctrine of champerty that was English common law, and it was largely abolished in America. I think it still exists in like New Jersey or something like that, but it's not in Texas. It hadn't been in Texas for forever, but there's wisdom in that old stuff. And barratry's been completely changed from what it was. It used to be, whipping up a case, spinning people up to litigate against each other for the lawyer's profit. That was barratry, common law barratry. These are real principles, and we see them play out in modern contexts. And so,
Well, the only lawyers in my case who've profited are my lawyers. Promise you that.
Yeah.
Did you have a question, Representative LaHood?
I do, but I'll let you finish.
No, Representative LaHood, go ahead. And if y'all want to jump in, feel free to jump in.
I just wanted to address your situation really quickly, which I very much respect.
I'm not
and-
paying you for legal advice.
No, you're not. No, you're not. Meter's not running.
Yeah.
No, I really respect where you find yourself, and what it is it's another abuse by a well-funded plaintiff who hides now behind someone with no assets to come after you and use the power of the lawsuit and the legal expenses you're incurring, knowing that you'll never be able to recover the award that you rightly received for bringing a motion that was valid. The answer is champerty, find a way to pierce the veil so you get behind the plaintiff who's a titular plaintiff but not the real plaintiff. You're the victim of exactly the kind of plaintiff that this whole statute is aimed at disarming by reversing the tables. I agree with Terry. We need to find a way to strengthen it so that someone who's in your position can't get beat by having a dummy, a false plaintiff, stand in the shoes where the real plaintiff should be.
I don't know anyone who's disagreeing with that.
I'm not either.
Well, I'll disagree with this part of it.
Representative Parsley.
I got a promotion.
Lee,
I don't
no, that's not a promotion, I promise.
I don't want to extend our night.
Lee,
But I will disagree that somehow this statute would prevent you from having recovered your attorney's fees. So what we just heard from Stacy is, well, this statute would just ruin it all for you, Jeff Leach. No, this statute would provide that you, the winner, could recover your fees as are equitable and just. which has been in the law for decades under the Declaratory Judgment Act. So my guess is that you would have a judgment today for $300,000 for your attorney's fees, which would still be uncollectible if you made this change that Mr. DeAyala has suggested in his filed bill. It would not change at all your case. It would potentially change the situation where you were misusing this SLAPP statute, or someone else is misusing the SLAPP statute, and that poor person who is a plaintiff in a lawsuit and cannot move forward in their lawsuit because you have misused the SLAPP statute and drug out their lawsuit for the next 5 years gets no relief. They get zippo. But under DeAyala's bill, they might get fees that are equitable and just. And that might deter some people from filing frivolous SLAPP lawsuits. And equitable and just, again, it's been in the law for a long time in the Uniform Declaratory Judgment Act. And I haven't seen anybody in front of this committee in the years I've been doing this up here saying, oh my gosh, the sky's falling with equitable and just lawyers' fees. It's what is wrong with saying to the courts, you can award fees as are equitable and just to the person who won in this situation.
2988 only gets the plaintiff their fees. It doesn't add any protection for you as the victim to get your fees and be able to collect them. 2988 makes it possible for the bad guy, the plaintiff, who is after you and trying to suppress your speech and trying to suppress your rights,
Right.
to get their fees.
If he's a bad guy, he ain't gonna get his fees.
Yeah.
All the time.
What trial judge is awarding fees to bad guys?
Can I respond real
Hold
quickly?
on, hold
that
on.
come from?
Hold on, Representative Parsley.
Well, for example, there's, real quick, there's one basis that a trial judge can decide to give the plaintiff their fees if you were to lose your motion and they were to win that motion. And that is that you brought your motion for an improper purpose. What's improper? I mean, your improper, my improper, his improper, they're all different. It's not defined anywhere in the statute. It's a vague term. So judges who have whatever interest they may have in promoting or protecting a plaintiff in that situation will drive that improper dump truck right through and wind up awarding fees to the plaintiff that should have gone to you. Your problem is you can't collect because the real plaintiff is hiding in the weeds behind someone who has no money. And that's exactly the kind of character flaw in plaintiffs that we are trying to attack with these statutes, is rich, powerful interests coming in and suing you to stifle your speech and limit your right to do your job here for the people in the way that you think is fit.
You know who I really blame for my situation? Well, a lot of people.
Is the attorney who filed the lawsuit.
Yeah. Can I respond real quick to this?
The attorney who filed the lawsuit.
Can I respond to this real quick? The equitable and just thing really scared me in this bill because that's such a loosey-goosey standard. It's basically a deferential to the trial court standard. And so the principle that I laid out, I said, you got to keep the Court of Appeals in the driver's seat because the plaintiff picks the venue, right? And now, it was a clown show what was filed against you. And so, yeah, you were going to win that because it was stupid, okay? But, and it was like the Supreme Court had just ruled against it, everything else. But, Right to Life's concerned about this stuff because they're getting sued, and no offense to Democrats here, in like Democrat courts who are, pro-choice judges, and, that's a tough trial court to litigate in. In the trial courts too, you're going to hear from Paul Chabot, who's one of my clients. The judge totally screwed the whole thing up. Just totally wrong in the orders, and they just sign whatever's put in front of them by the winner of the motion, right? So you got to keep an objective standard that puts the Court of Appeals in the driver's seat so that we can rely on it, and you don't just give total deference to a trial court that the plaintiff, the belligerent plaintiff, chose.
I'm gonna allow the author of the bill, Representative DeAyala, to ask a question or two, and to you four. There are other witnesses behind you that are shaking their head and
kick us
not
out,
doing all sorts of stuff.
Really quickly on the lawyer,
Yeah.
you're onto something.
I am onto something.
Yeah, lawyers are ethically required to investigate the facts before filing a suit and confirm for themselves that the facts have merit, such that the suit meets the prima facie standard of a case and that they can go forward and do it. If they don't do that, or if they investigate it and ignore it because they're getting paid a lot of money to bring that suit, okay, they are engaging in an ethical violation.
My attorney, I got sanctions against him, and you know what he did? He turned around and sued me, the law firm, and the state district court judge in federal court.
Well, at the end of
So I get you. I think we're all
disbarment.
agreeing here, but it's turning into in many cases it's a cartoon. It's turning into a circus, and it's not meant to be. There's many other cases just like mine of people who are not here today, are not able to testify, are not able to travel here, don't hold this microphone, and the blessing of having this opportunity to speak out like I have, that I'm speaking on behalf of. They are dealing with this in real time now. Representative DeAyala, I want to let you jump in.
First of all, I appreciate the discussion, and this is what I was hoping to have before this hearing, more of this. When I did my layout, I talked about the lenses in which we look at this. And you're looking at it from a broadcaster's lens, and I know the lens you're looking at it and the rest of you. But I want to give you a scenario, because in my practice, I deal with this on a regular basis, and I don't have a First Amendment practice. It's in construction litigation. It's in oil and gas litigation. It's in contract, but with business torts litigation. It's in all sorts of things, because anytime you speak or associate, you can trigger this. What I'm not hearing and almost begging for, because I do like to solve problems. The reason I decided to do this job, not just the $600 a month, is we get to solve problems. And as a practitioner of 33 years, this is one of the problems that my colleagues are saying is just destroying, and the courts of appeals and the Supreme Court, it's just cluttering it up. I'm going to give you one example. I have a case and a client who is a plaintiff in a lawsuit, and the lawsuit has to do with the fact that he's supposed to get paid a percentage of an earnings of a company owned by a family, and he didn't get paid, and I told Tony this story. And in 2019, we filed this lawsuit. Got slapped right there. 2.5 years later, bad slap motion, comes back down, no fees. We go on. Right before trial, a few months ago, amend our lawsuit to add a tortious interference claim. Still, same case. Slapped again. Go wait 2.5 more years. My client's in his 80s. This is a design. There's no incentive to keep this defendant from filing these motions because there's no consequence to filing a bad one. So that's why I've reached out to so many people and said, this is the problem we're facing. If you want to save the TCPA for the good that it does, and it does a lot of good, and you all profess the good that it does, help me fix the bad that it does, the people that abuse it. So I say that because what I'm not hearing is how to solve those problems. And that problem, I can tell you story after story after story. And it's a big deal. So I say that because everything you're saying, for the most part, I don't argue with. But it doesn't resolve what I'm trying to resolve here. I'm not anti-TCPA. I'm anti-bad TCPA. So
You're anti-abuse.
I'm anti-abuse.
Yep.
That's what I mean.
Same.
So, and there's really no consequence for that. There really isn't. Right now, the statute says the court may, if it's frivolous. So any judge that awards fees on the other side is basically saying, this is exhibit number 1 to the malpractice lawsuit I'm doing for this other lawyer. Basically, that's the order they're signing. They don't sign those orders. It's just, you don't do that to practitioners unless it's just super, super, super obvious. That needs to be fixed. Like I said, my door's open, my phone's open. I'll give you my cell phone. Happy to talk.
Yeah.
Thank you.
Thank you. Members, any other questions for this panel? Oh, yeah, Representative LaHood, I'm sorry. Representative LaHood.
No, it's all right. Thank you, sir. So I'm reading 27.002, the purpose. I'll be honest, before the legislature, I didn't even know this existed. The purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of persons to file meritorious lawsuits for demonstrable injury. And so I guess my question to y'all is this, because like whenever like TTLA and TLR agree, or whenever someone's advocating for the little guy, and then I have Sinclair and WAI, like that piques my interest when two sides that I would think are typically at odds are saying, hey, we're aligned on it. And so I guess my confusion is, how is it that y'all are aligned? And I'm not attacking. I'm just really trying to figure it out, because from what I'm hearing, and I'm sorry you went through that, Chairman, but it sounds like everyone has the same frustration with the abuse. My concern with taking out shall is that when you give the court discretion, the shall part is what protects the guarantee. If abuse is found, to suppress speech, that shall is the guaranteed protection of our guaranteed constitutional, inalienable, God-given right. So I'm trying to figure out if there's a balance and how y'all are aligned. Not y'all aligned, but I mean, why y'all are on the same side. That makes sense. I'm trying to get my head wrapped around it all.
This bill has definitely made strange bedfellows.
And did before 2011. And that was the 2011 reforms, which deal with those strange bedfellows, the abuse that had been identified.
You mean the 2019 reforms?
I'm sorry, 2019.
Right.
I did.
That's my bill.
Representative LaHood, the reason we're here is we represent newsrooms. We represent the press, okay? We have the exact same interests that his client does, which is these suits get brought to make it impossible for our clients to report news that they have worked hard to verify, because there are standards, to report news because they'll get crushed in litigation from plaintiffs who are well-heeled and well-connected. Newsrooms don't have the budgets they used to have either. And I represent local newsrooms here in Austin, not just networks, as does she. So that's the alignment. Those interests are the same, and it's about preserving free press, freedom of speech, those First Amendment freedoms from lawsuits that are brought, frankly, in bad faith to stifle critics, to stifle investigative reporting. That is why this statute was passed, and that's why in 36 states it exists. And it says shall in almost all those places, for the reason you say.
So everyone on this panel wants the SLAPP statute to protect First Amendment rights. It's the second element of 27.
Representative Parsley, move the microphone closer.
It's the second element of 27.002 that's not getting respected. There's two things in 27.002. Protect First Amendment rights, allow people to have access to courts for injuries done to them. The first of those, that shall, is doing a great job protecting, along with everything else the statute has in it. I would like for this panel to talk about the second one of those. That's what Mr. DeAyala is talking about. He's talking about the second right, the right to file a lawsuit and to be able to proceed to trial without having to spend 2.5 years on appeal, or maybe 2.5 years on appeal twice, as Mr. DeAyala has described. That's what we need to talk about. So everybody up here is filibustering on the thing that we all agree on, as you've noted. What about the side that we don't agree on? What are we going to do about the people who get slapped, who get an anti-slap statute motion to dismiss filed, and then the appeal follows, and they're stuck, not being able to pursue a legitimate lawsuit for the next 2 years, 3 years, 5 years?
Tony, you get the final word on this panel.
Briefly, I think I can give an answer that kind of goes to both of these questions. Why do we have this statute? Why are we all united? Because we've got a slap suit problem in Texas. These suits are getting filed all over the place. I'm constantly telling people, they get offended and they're like, we need to sue for slander. And I'm like, no, you don't, okay? You don't need to sue anybody. File a hurt feelings report and settle down,
you're
right?
not gonna win.
Okay, and you're not going to win. You're going to end up paying that guy's fees. And so I'm able to stop people from doing stuff. But we have a slap problem. The statute involves trade-offs, okay? It's a trade-off. It is an obstacle in lawsuits, right? And we don't want to make it some, horrible barrier for real legitimate lawsuits, but we have to protect the people who it's intended to protect. So I think there are ways to work on it. I don't think the idea of the, shall, if it's frivolous, it's a shall. I don't know. I don't think it's necessarily a bad idea. But what we need to talk about is how do we speed up the appeals? How do we get these things to be more efficient? I mean, there's so many ways we can work on this to balance that, to say, legitimate lawsuits should be able to proceed, and those people who need protection, they ought to be able to rely on it and know they're going
Well,
to rely on it.
I don't know what you're doing the rest of this week and this weekend, but work with him.
But he
Because
called me, and we had a great chat. It was great.
All right.
We'll be happy to.
I'm serious. I believe that we can find common ground, and
Thank you.
all right, thank you. Thanks to this panel. All right, let's move on to the next panel. Thank you. That was entertaining.